Good day, everyone. Welcome to the last discussion of the topics under Introduction to Criminology. In the first, second, and the third episode, we discussed about preliminary topics of criminology, what criminology is all about, and what are the employment opportunities in the employment market that awaits for a graduate of the criminology program. We also discussed about the different factors that would affect criminality. Like say, for example, we talk about sociological factors, geographical factors, as well as biological factors that will cause a person to commit crime. In this last episode, the discussion will mainly revolve on the characteristics of the criminal law, as well as the classifications of criminals. And we will also be discussing about crime rate, crime volume, crime clearance efficiency, and crime solution efficiency. Before we discuss about the application of the criminal law or the characteristics of our criminal laws, let us define first what is really a law. So a law is a general rule of conduct, just, obligatory, laid by legitimate power for common observance and benefit. So we have we have various laws in the Philippines right now that regulate our conduct, the way we behave in the society. And this regulation is something that is obligatory, meaning whether we like it or not, we have to abide simply because this is our obligation. Okay, our obligation to observe these various laws set by the legitimate power, set by the government to us. So we have three basic principles of application of the criminal law. We also call this one as the characteristics of the criminal law. So we have three: generality, prospectivity, and territoriality. When you will be in the second year level, the same topic will be repeated in that subject, considering that part of CLJ, or Criminal Law and Jurisprudence, which is one of the major areas in criminology, will actually tackle about this topic. But to give you a heads up on what are the characteristics, we will be emphasizing on what generality is, what prospectivity is, and what is territoriality. So the first one is generality. So when we say generality of the criminal law, it means that our laws in the Philippines will apply to all, irrespective of whatever background that you have or any societal status that you have in life. You are bound to follow the law. So to simply say, whether you are poor or rich, educated or not educated, illiterate or not illiterate, any circumstances or any background in life, you are bound to follow the law. So the law should be equal to everybody, irrespective of whatever societal status again or circumstances that you have in life. When we say prospectivity, it means that our laws have no retroactive effect. Okay? Our laws have no retroactive effect. Let us say, for example, last 2010, you were not able to wear a helmet while you are driving. Okay? You were not able to wear a helmet while driving. And when 2015 came, there is a law relative to mandatory wearing of the helmet during driving. So this is just an example. So if the law is enacted in the year 2015 and you did not wear a helmet in 2010, you will not be punished on the act committed in 2010 simply because the law was approved or enacted in 2015. So since there is no retroactivity on the provisions of the law, you will not be punished on the act, on the previous act, which was not actually considered as a crime during that time because there was no law punishing it. Okay? We call that one as prospectivity. Okay? Tawag ana is prospectivity. For example, another example is on Anti-Voyeurism Law, which is Republic Act 9995. In that law, it regulates that or it prohibits a particular person to record sexual activities without the knowledge or without the consent of the partner. That's anti-voyeurism law. Now, if you committed a particular act, let us say 2005, and then there was a law on anti-voyeurism that was approved in the year 2012, the act of recording in 2005 will not be considered as a crime, and it will not be punished in the year 2012 simply because the law again has no retroactive effect. Remember guys, in the case of logomacy, when we say logomacy, there is no crime if there is no law. Okay? Logomacy again, there is no crime if there is no law. So if a particular act is not considered as a crime simply because there is no law punishing it, even on the later years, there will be a law that prohibits the previous act, still there will be no punishment that will be made, considering that our laws have no retroactive effect. Okay? But if in case a particular law is in favor of the accused, okay? If in case a particular law is in favor of the accused, that's the time that the law may or might have a retroactive effect to a particular situation. Okay? That's prospectivity. Now, when we say territoriality, territoriality means our criminal laws can only be applied within the territorial limits of our country. For example, if a particular person will commit murder in America and he's a Filipino, our laws will not extend to America. It will only be limited within the boundary, the territorial or the area limits of the country. So if a particular act is committed outside the country, the place or the government where the act is committed has the responsibility of punishing the person. In that case, if a particular act is a criminal act is committed in any foreign countries, that country will have the responsibility of punishing that Filipino person. Our laws will not extend, okay? Will not extend to other countries. So again, generality, our laws is applicable to everybody irrespective of whatever circumstances, any background or societal status in life. Prospectivity means our laws have no retroactive effect, and territoriality means our laws are only applicable within the area or territorial limits of our country. Now we have general sources of the criminal law. One is common law, the other one is statutory law. So when we say common law, this refers to our body of customs, our practices, our traditions, and precedents developed over time without formal legislative process. So basically, when you say common law, these are the laws that were present since the beginning of time. For example, we have divine law. An example of divine law is the right to choose a particular religion, all right? Or the freedom to religion, to practice our belief or religious belief. So if you are a Muslim, you are a Christian, you are a Seventh-day Adventist, you are a born again or whatever religious sect you belong to, that is one of your rights, okay? One of your rights under the divine law. So this divine law already existed since the beginning of time. So that is one of the types under the common law. Aside from the divine law, we have the natural law. What are examples of natural law? Like say, the right to be happy, okay? The right to be happy, the right to love, the right to marry another person, the right to travel, okay? These are natural law, okay? These are natural law. When we say moral law, this is a kind of law that actually regulates a particular standards, moral standards. For example, honesty, integrity, okay? The right to be, or the provision about honesty, the provision about integrity, the provision of being a person with entwined with moral ascendancy. So kani siya tanan puro ni mga moral law. Okay? Moral law na siya as long as it targets about moral standards. So all of these are part of the common law which already existed a long time ago. Even if you will go to the biblical times, even if there was no particular enactment of a law from a legislative body, Adam and Eve already knew that there are laws that you have to follow. The law about worshiping the Lord, which is a divine law, the law about marrying a particular person or having a relationship with a person, that's part of a natural law, and of course the moral law about not cheating or not be tempted. So these are practices and customs a long time ago. So this form part of what we call as common law. Now, the difference between common law and statutory law is that in common law, it already existed a long time ago, and it does not actually need a formal legislative process. But in the statutory law, these are laws that are developed through formal legislative process. So this refers to our special laws already. This refers to our Republic Acts. Okay? For example, Republic Act 9165, a law that regulates against illegal drugs. Okay? So that is an example of statutory law. Republic Act 9995 about anti-voyeurism, that is an example of statutory law. As long as the Congress or the Senate will enact or pass a bill that turns into a law upon the approval of the President, that shall form part as one of the statutory laws. Okay? So that's the difference between common law and statutory law. So again, we have three characteristics of the criminal law. Number one, again, generality. Number two, prospectivity. And the last one is territoriality. Now, let us go back to territoriality. There are rules on jurisdiction over private or merchant vessels while in the territory of another country. Now, we have two rules that will apply. Number one is French rule, and the other one is English rule. Again, these rules concern about a foreign merchant vessel. Okay? A foreign merchant vessel that enters within the territorial limits of our country. Okay? A foreign merchant vessel from other country, of course, that enters within the territorial limits of our country. So we have two rules. One is French rule, the other one is English rule. Now in French rule, crimes committed on board of a foreign merchant vessel while on the waters of another country are not triable in that country unless those affecting the peace and security of that country or the safety of the state is endangered. English rule that such crimes are triable in that country unless such crimes affect merely the internal management of the vessel. This is also known as the Anglo-American rule. This is the rule that we followed in our jurisdiction or in the Philippines. This includes continuing crime committed on board a foreign vessel sailing from a foreign port and which enters Philippine waters that could be triable in our court. So what we are following is the English rule. So to make us understand, we will go first with the French rule. So in the French rule, if there is a particular crime, let us say killing, okay, killing a particular person while on board a foreign merchant vessel, the crime of killing will not be triable in that country where the vessel is located unless it affects the peace and the security of the country. So if there is a killing, a person kills another while on board a particular vessel and the person died, okay, the person died, Even though there is an act of murder or homicide while on board the vessel, the country or the court inside that country will not put the suspect into trial. Okay? Unless if the killing of the person while on board was committed in the vessel, and it turned out that the vessel docked on the port of that country and it causes chaos. Okay? It causes chaos or it affects the peace of the people inside the port. That's the time that the crime will be tried in that country. Okay? Again, example, gipatay siya while on board a foreign vessel. And then pagpatay, nidunggo ang vessel sa port sa kanang country, tapos nagkagubot ang mga tao sa pantalan. Tungod kay naka-affect naman na siya sa peace and security, considering nga nidunggo siya, pwede nang matried or pwede nang masitol ang kana nga kaso or kana nga krimen dito sa korte, ana nga country. But if in case the act of killing again is only done within the vessel and it does not affect the peace and security, meaning diha lang yun siya sa dagat, galutaw-lutaw ang vessel, diha ra ang pagpatyanay, diha lang ang killing gihimo, wala naka-affect sa peace and security, pwede lang nga dili to siya i-tried, or that crime will not be tried in the country where the particular foreign merchant vessel is located. But then again, we are not following the French rule. We are following the English rule. These crimes of killing, even if it is on board in the English rule, is still triable, can still be tried in our Philippine courts unless such crime merely affects the internal management of the vessel. Like say for example, there is a commotion between the captain of the boat and his subordinates. Okay, the commotion is caused by internal management issues. So at that instance, such act cannot be tried in our country because it merely affects the internal management. Okay? Panaglalis or arguments between one subordinate to the other while on board. These are acts that cannot be tried in our country considering that it merely affects the internal management. But then again, if it is a crime that does not include internal management, like the act of killing, under the English rule that we observe, that crime can still be triable in that country or in our country. So we are following the English rule. Now let us define what is a criminal law. So a criminal law is a branch or division of law which defines crime, treats of their nature, and provides for their punishment. So if you will go to Criminal Law Book 1 and Book 2, you can find various crimes, okay? It enumerates various crimes. It defines a particular crime and what would be the nature of that crime. At the same time, it provides the number of years or the number of days or months as a punishment or a sort of punishment to the particular crime. For example, if murder is the crime being defined in the criminal law, it will also provide the number of years. It would say that the punishment of murder, for example, is reclusion perpetua or 20 years and 1 day to 40 years. So a criminal law defines the crime, it treats the nature of the crime, at the same time, it includes in its definition the number of years or the number of months or days that a person will be imprisoned or the person will be punished. Now, crime is defined as an act or omission in violation of the existing laws. Now, there are actually three terms or three phrases that I want you to consider. Number one is the word act. Number two is omission. And number three would be existing laws. Okay? Now, when we say act, it refers to our external actions. Okay? Act is internal. Alright? The way we exhibit our actions. This refers to acts. Okay? An act. For example, if we punch a person, the punching is considered as an act. Okay? So if you plan to kill a person, internal planning that only happens within your mind cannot be considered as an act. An act in the definition of crime must be external. Okay? If you only plan to kill a person, that shall not be considered as a crime simply because it is the act of planning that is inside your head is internal. It is not external. But if you already perform the plan through your actions, that can be part of crime. Next is omission. When we say omission, this refers to our responsibilities to the government that we failed to perform. Okay? So when we say omit, our responsibility, we have the responsibility, but we fail to perform such a responsibility. For example, we failed to pay our taxes. Okay? Our responsibility is to pay taxes, but we failed to pay or we failed to oblige. So that is omission. Our responsibility that when we see a person under the verge of death, our responsibility is to provide assistance. But when we see a person that is dying because of an accident and we just escape from the crime scene, okay? We just escape from the scene or from the incident and then pretend as if we did not see the person who is at the verge of death, there will be a crime that will be filed, or a complaint that can be filed against us. Why? Because abandonment of a person on the verge of death is a crime. Our failure to provide assistance is an example of omission. Why again? Because it is our responsibility to provide assistance once the person is dying. Okay? So again, when we say act, it refers to our external actions, the way we exhibit our actions. Omissions, these are our responsibilities, but we fail to perform such responsibilities. Again, example, abandonment of a person on the verge of death, and the other one is tax evasion. Now, for an act or omission to be considered as a crime, there should be an existing law that punishes it. Okay? There should be an existing law. Because if there is no existing law that punishes a particular act or an omission, such act or omission shall not be considered as a crime. For the act or omission to be considered as a crime, there should be an existing law that regulates it. Okay? There should be an existing law. For example, if a person records the whole activity, the whole sexual activity without the knowledge of the partner, if there is no law punishing it, such act of recording cannot be considered as a crime. But considering that we have Republic Act 9995 on anti-voyeurism law, then such act of recording can now be considered as a crime. Okay, why? Because there is an existing law that regulates it. Okay? So again, crime could be an act or could be an omission, and this act or omission should be in violation to the existing law. So there are three stages in the execution of crime. It could be attempted stage, frustrated stage, or consummated stage. For the criminology students who are already graduates, or for those students who are already in the senior years, I think these stages are already very familiar to you. But for the first year cadets, let us discuss, all right? Let us be acquainted with the three stages. So when we say attempted stage, this is the stage in the execution of a crime where the offender commences commission of a felony directly by overt acts but does not perform all acts of execution which should produce the felony by reason of some cause or accident other than his spontaneous desistance. Like say for example, you shoot a person using a firearm, but when you execute the shooting, it so happened that by coincidence the person was not hit by the bullet coming from your firearm. In that case, you perform the act, but not all of the elements of the act are present, considering that you failed to hit the victim. You failed to hit the person. You failed to hit the target. So in that case, since you failed to hit the target, the act of execution shall form part within the attempted stage. Okay? Another example, when you are about to steal a particular cash coming from the drawer of a person, and then while you are doing the act of stealing, it so happened that you were caught. Okay? Nasakpan ka, you were caught by the guy or the owner. So in that case, since you performed the act but you failed to perform all of the elements, considering that there is a reason, and the reason is you have been caught, in that case, the act of execution shall be under attempted stage. Okay? Next, frustrated stage, a stage in the execution of a crime where the offender performs all the acts of execution which should produce the felony as a consequence, but which nevertheless do not produce it due to some cause independent of the will of the perpetrator. So, in frustrated stage, you perform all of the elements of the acts. Okay? You perform all of the elements of the acts. But after performing it, there is a particular reason, it could be through accident or by other circumstances, that fails for the consummation of a particular act. There is a reason that still fails you. Okay? That still fails you. Okay? To perform all of the elements. For example, again, you shoot a person using a firearm. Okay? You shoot a person using the firearm. And the person was hit, let us say, at the abdomen, hitting the vital organ of the person. That may cause him to, that will bring him to death. Okay? You hit a person to the abdomen, and while the bullet travels to the abdomen, it hits a vital organ of the body of the victim. But when the victim was brought to the hospital, it so happened that he was able to survive. Right? He was able to survive the fatal wound. Since he was able to survive the fatal wound, in that case, the act of execution will form part under frustrated stage. But if the person was only hit by, let us say, gas lang, he was slightly hit by the bullet, alright? And after he was hit by the bullet, he only suffered abrasions or a minor wound from the bullet. In that case, if the wound is not enough to cause death of the person, again, the execution shall form part under attempted stage. Unless the wound is enough to be considered as fatal or makamatay gyud. Okay? So if it is considered as fatal or lethal, that wound shall be the basis in transitioning to frustrated stage. So again, if the person is hit by the abdomen, or say he was being hit at the, at a portion or a part of his head was being hit by the bullet, but still he was able to survive, even though the wound was considered as fatal. In that case, because he survived, there will be, it will be considered as frustrated stage. If the person already successfully stole the money from the drawer of another guy, but at the point that like he was escaping from the crime scene, but yet he was caught, right? He was caught while he was escaping from the crime scene. In that stage, it shall be considered as frustrated. Okay? Attempted, if in case he was about to steal the money, but then again he was caught. But if he already stole the money and he was on the point of running or the point of escaping from the crime scene, but still he was caught and arrested, the act shall be under frustrated stage. So I hope nasabtan ni. If all of the elements are performed, like you shoot a person, the person died because of the bullet, okay? Then the act shall be consummated, under consummated stage. When the person stole the money and he was not caught, and he successfully escaped from the crime scene without being arrested, again, the stage shall be considered as consummated stage. Okay? So that is the difference between attempted stage frustrated stage, and consummated stage. In order for us to understand more what is a crime, let us go now to the general classification. There are three general classification of crimes. A crime could be considered as a felony, a misdemeanor or infraction. These are two terms that are the same, misdemeanor and infraction. The third one is offense. Okay? So I hope when you reach fourth year level or when you graduate, you will still remember this general classification of crimes because these are very important. A particular act or omission that violates the revised penal code or the RPC or the criminal law shall be considered as a felony. Okay? So again, in criminal law book 2, if you will read all of the crimes in criminal law book 2, that crimes, or if a person committed such crime, then the crime shall be considered as a felony. Why? Because the violation is actually under the revised penal code or the criminal law. But if a particular violation, a particular act or omission violates only the city ordinance, municipal ordinance, like say for example, ordinance on spitting, ordinance on throwing garbages, ordinance on curfew, ordinance on the observance of the pandemic. And if the person violates an ordinance, whether it is a city, municipal, barangay ordinance, the act or the omission shall be considered as a misdemeanor or infraction. If a particular act or omission violate any special law, that act or omission shall be considered as an offense. Now, the question is, what are special laws? When you say special laws, these are laws that are enacted by the Senate or the Congress. Like say for example, we have Republic Acts, we have presidential decrees. These are examples of special laws. Special laws are again the laws that are enacted by the Senate and the Congress. For example, Republic Act 9995, Anti-Voyeurism Law, Republic Act 8551, Republic Act 6975, Republic Act Presidential Decree 603, Republic Act 9344. All of these are example of special laws. So if we target like PD 603 or the Child and Youth Welfare Code, and the particular criminal act is in violation of that code or in violation of PD 603, then the crime shall be classified as an offense. Why? Offense in the sense that it violates the provisions of a special law. So that's the difference between felony, misdemeanor, offense. So kung mangutan ako, galabay o garbage, wala na segregate ang garbage. So unsa may tawag ana? Wala. Failure to segregate the garbage is what? Felony, misdemeanor, or offense? So your answer should be misdemeanor or infraction because that is a violation of the city or municipal ordinance. If I will ask you, how about treason? Treason. Unsa man na treason? Asa man siya nabilong? O nabilong siya sa revised penal code. So if a person commits treason, unsa tawag sa crime? Felony. Okay? Child abuse. Okay? Child abuse. Violation sa Republic Act 9344 or PD 603. So unsa tawag niya? Offense. Why? Because under man siya sa special laws. So these are the difference between felony, misdemeanor, infraction, and offense. Now, aside from the general classification of crimes, we also have classification of crimes according to the mode or manner of commission. So do not be confused, cadets, that we have a lot of classifications. All we have to do is to take a look at the nature of the crime, and we can classify it according to different areas. So again, the first one, the offense, felony, and misdemeanor are general classifications. Okay? General classification of crimes. Ang sunod is a classification of crime according to the manner. Okay? How, when you say manner of commission, how the crime is committed. Okay? So, it could be formal crime or material crime. What is a formal crime? A formal crime, these are crimes which are consummated in one instant or by a single act. Material crimes, these are crimes which necessitates the three stages of execution. For example, we have attempted murder, frustrated murder, and consummated murder. If a particular act like murder consists of three stages, that shall be considered as a material crime. Okay? Material crime ang tawag ana. Why? Because it contains three stages. It contains attempted stage, frustrated stage, and consummated stage. But if a particular crime is consummated or can be consummated in one instant, meaning there is no attempted, there is no frustrated, or there is no consummated stage, there is no frustrated rather and attempted, and the act will become automatically under the consummated stage in the performance or in one instant or by single act, such shall be considered as a formal crime. Okay? For example of formal crime, let us say slander. Okay? Pagpakaulaw. Okay? Pagpakaulaw, slander. In slander, wala may ginatawag nato og frustrated slander. Wa pa ta ginatawag og attempted slander. So the moment that you spread rumors, false accusation against somebody to the point that somebody was humiliated because of that rumors or false accusation, slander can be filed. Automatically, consummated ang act. When you say consummated again, nahuman nimo, na perform nimo ang tanan nga element sa crime. So, wa may attempted, wa may frustrated nga slander, automatically, makonsidered siya og formal nga crime. Okay? Formal crime. Another example of formal crime is corruption. So, there is no such thing as attempted corruption, frustrated corruption. Automatically, when you steal money from the government, automatically, the act is considered as consummated. So, corruption is an example of a formal crime. Another example is rape. O sa man ang rape, na may attempted rape, frustrated, or na may consummated, na may stages ang rape. So, pwede siya makonsidered as material crime. Okay? Treason. Asa man mabilong ang treason? Na by attempted treason? Na by frustrated treason? Wala. So, sa may tabo, sa treason, pwede nga makonsider siya o formal crime. So again, when we say formal crime, if a particular act in one instant be considered as consummated. Material crimes, these are crimes that consist of the stages, the frustrated, the attempted, and the consummated stage. Now, crimes are also classified according to plurality. Unsa may bot ipasabot og plurality, hidaghanon. Alright? The number of crimes or the number of acts. Simple crime, a single act which constitutes only one offense. Alright? Only one offense. Complex crime, when a single act constitutes two or more grave felonies, we call this one as compound complex crime, or when an offense is a necessary means for committing another, like complex crime proper. For example, you say murder, o saraman, murder, so simple crime. But if you will say rape with murder, o pwede siya matawag og complex crime. Or will you say reckless imprudence resulting to homicide? That is an example of complex crime. Or burglary with theft. That is an example of complex crime. So for short, when you say complex crime, there are two crimes being committed but are integrated as one. So meaning, two crimes being committed, but still during the trial, there will only be one trial, there will only be one complaint, there will only be one punishment. That's the difference between simple crime and complex crime. So if you see the conjunctions like with, alright, like burglary with theft, rape with homicide, robbery with homicide, these are example of complex crime. Robbery with homicide, two crimes, robbery and homicide. While committing robbery, it came up to the point of killing someone. So robbery with homicide. Unsa na siya? complex crime. Pero kung mayon dito, robbery lang, o simple crime. Homicide lang, simple crime. Robbery and homicide, meaning, robbery o homicide, duha ka krimen. So, simple crime ra Japon. Robbery o homicide, simple crime. Pero kung robbery with homicide, complex crime. Rape with homicide, complex crime. Right? Burglary with theft, that is also an example of complex crime. So if you will say, murder, ato i-classify ang murder. Sa general classification, asa man nabilong ang murder? Ang murder is actually enumerated under the revised penal code. So it shall be classified as a felony. As to the mode or manner of commission, murder is a material crime. Why? There are 3 stages. In the classification according to plurality, murder is a simple crime. Nganong simple crime? Kay usara siya. Pero kung gibutangan og with rape with murder, pwede siyang matawag og complex crime. Pero murder naman, ang tawag ana is simple crime. So the next one is on the classification of crimes according to its result. So crimes can be classified as acquisitive crime, extinctive crime. So if a particular act or if a particular offender acquires something as a consequence of his criminal act, it shall be considered as acquisitive, from the root word acquire. Extinctive, once a particular crime resulted to destruction. So when you say acquisitive, you gain something, like a property. Extinctive, you destroy something. So if I say robbery, you acquire something, like a money. So sa tawag niya, acquisitive crime. Theft, you acquire a property. So theft shall be considered as acquisitive crime. Murder, since you destroy a life, all right? Arson, like kindling fire on a building. Since it destroys a building, it destroys a property, or you kill somebody and it destroys the person, it shall be considered as an extinctive crime. So that's the difference between acquisitive and extinctive crime. Crimes are also classified according to the period of commission. If it is committed during a period of the year, like say for example, in the previous discussion we discussed about crimes during summer season and crimes during rainy season. So if it is committed like a certain season, like summer season, and the crime is crimes against person, like say murder, homicide, physical injury, and it is committed during summer, it shall be considered as a seasonal crime. Okay? Seasonal crime. If a particular crime is committed when opportunity arises, or when there is a situation like you have been hit by the elbow of your opponent while playing basketball, and then you go to your opponent and you punch him several times and your opponent suffered physical injury, in that case the physical injury is an example of a situational crime. So you have to, in classifying crimes according to the period of commission, you have to take a look, number one, the period, right? The period of the commission. And number two, you have to take a look on the nature as to how the act has been committed. Okay? So that's how you will define seasonal and situational crime. So in the previous slide, we discussed about simple crimes and complex crimes. Simple crimes has another name. We call it as instant crime, and complex crime is also called as episodal crime. So again, when we say instant crime or simple crimes, this is a crime which only considers one act, like murder or homicide. That's an instant crime. But if it contains series of acts, like again, rape with homicide, robbery with homicide, these are example of episodal crimes or complex crimes. Now, crimes are also classified according to the location of commission. It shall be considered as static crimes if committed in one place only, like murder, homicide, theft, usara man na kalugar. So di po siguro og mupatay kag tawo diri sa usa ka lugar, paabot sa unahan, dalon mo na tawhana para usbon ni patay dito. So dili pwede. Static crimes, yeah. Continuing crimes, those that can be committed in several places. Like say for example, illicit drugs or illegal drugs. That is an example of a continuing crime. Crimes are also classified according to the mental faculties. It could be rational crimes or irrational crimes. Okay, so for you to find out if a particular act is rational or irrational, you have to consider the psychological sanity of the person, whether he is insane or not. So if a person commits a crime and he is normal, he knows what he is doing, whether what he is doing is bad or good, the person is considered as a rational individual. So therefore, since he committed a crime and he is a normal person, that crime shall be considered as a rational crime. Irrational crimes are those crimes committed by persons who are suffering from psychological disorders like feeble-mindedness, idiots, the imbeciles, the insane person suffering from schizophrenia, and any other form of psychological disorder shall be considered as irrational crime. So, if you have been stoned by an insane person and you suffered serious physical injury as a consequence of the particular act, the crime committed by the insane person shall be considered as irrational crime. But then again, the insane person under the law is exempted from punishment. We also have classification of crimes according to the type of offenders. We have white-collar crimes and blue-collar crimes. For white-collar crimes, these are committed by persons in the higher or upper socio-economic status. These are usually committed by professionals. Like say for example, politicians committing corruption. That is an example of white-collar crime. Blue-collar crimes are those committed by ordinary persons, like you are an individual who does not have any employment opportunity. You are not employed or you don't have a stable job, then you steal a particular money from a person. The crime is considered as a blue-collar crime because you is considered as an ordinary individual. The second to the last classification is in accordance to the nature of the acts being committed by the person. So crimes can be mala ensi or mala prohibita. Okay? Again, these terms will come out when you will be in the second year level once you will be taking Criminal Law Book 1 and Book 2. So when we say mala ensi, these are crimes that if you take a look at its nature, it is wrong, it is evil. Right? It is evil or wrong by its nature. Mala prohibita, these are not actually evil by nature. These are not wrong by nature, but they only becomes wrong or they only becomes illegal because there is a law that regulates such act. For example, like you throw your garbage. You just throw your garbage anywhere. Throwing your waste is not basically evil. It is not basically wrong to throw your garbage. But since there is a law prohibiting it, or there is a law that regulates on the throwing of the garbage, like you segregate it, you throw it on a proper trash can, that provision that provision of the law is something that defines the act of throwing of the garbage. So therefore, if you still throw your garbage anywhere, that can be considered under mala prohibita. Okay? A crime that is not considered actually as evil, but it only becomes illegal because of the law that define it. Curfew, right? Curfew hours. Curfew or strolling in the streets, wandering around during nighttime is actually okay. It is not wrong. It is not evil in its nature. It only becomes wrong or it only becomes illegal because there is a law punishing it. So such crimes can be considered as mala prohibita. But if you will go to murder, look at murder. Even if there is no law that punishes it, by its nature, murder is bad. Murder is evil. Stealing is evil also. So these crimes can be considered as mala ensi because if you take a look at its nature, whether there is a law or whether there is no law, by its nature, killing or stealing are actually evil or wrong. So it shall be considered as mala in se. How about drugs or violation of Republic Act 9165 on illegal drugs? So if in case a particular act is a violation of our special laws, okay, if the particular act is a violation to any special laws, it shall be considered also as mala prohibita. Okay? Kung violation siya sa special law. So, ang 9165 is a special law. So, any violation in that law shall be considered as mala prohibita. We also have classification of crimes according to the gravity of penalty. It could be grave felony, less grave felony, and light penalty. We will start with the bottom, the light penalties. Infractions of law or those crimes punishable by aristo minor. What is aristo minor? Aristo minor is 1 day to 30 days. So if a particular crime is punishable by 1 day to 30 days, it shall be considered as a under light penalties. Okay? Less grave felonies, penalties from aristo mayor to prison correctional, including destierro and suspension. So let us define the terms. When we say aristo mayor, the penalty is 1 month and 1 day to 6 months. I repeat, aristo mayor is 1 month and 1 day to 6 months. Prison correctional. Prison correctional is punishable with a time frame of 6 months and 1 day to 6 years. I repeat, 6 months and 1 day to 6 years. So if a particular crime is punishable with aristo mayor, 1 month and 1 day to 6 months, and prison correctional, 6 months and 1 day to 6 years, that shall be under less grave felonies. Destierro is a modern form of banishment, okay? When you say banishment, like if you committed a crime in Dumaguete City, Negros Oriental, and you have been punished with destierro, like you are not allowed to enter 25 kilometers radius from Dumaguete City. So you have to count 25 kilometers with the 4 directions from north, east, west, south, and you're not allowed to enter at least 25 kilometers, because once you enter, you will be in contempt by the court. So it's a form of punishment, all right? So it could be 25 kilometers, maximum of 250 kilometers, depending on the judgment coming from the court. Suspension also, like suspension, a particular government employee has been suspended, that will also form part under less grave felony. Grave felonies are those which attaches capital punishment or afflictive penalties. Now, when can you consider that a particular penalty is afflictive? It is afflictive if the penalty is from prison mayor up to reclusion perpetua. Okay? So, unsa man ang prison mayor? Prison mayor is 6 years and 1 day to 12 years. I repeat, unsa ang prison mayor? Prison mayor is 6 years and 1 day to 12 years. So, note sa prison mayor is what we call as reclusion temporal. What is reclusion temporal? Reclusion temporal is 12 years and 1 day to 20 years. Again, 12 years and 1 day to 20 years. That's reclusion temporal. The next one and the last is reclusion perpetua. Reclusion perpetua is 20 years and 1 day to 40 years. Okay? 20 years and 1 day to 40 years, that is reclusion perpetua. Capital punishment refers to death penalty, but right now, we no longer have death penalty. Death penalty has it has already been considered as obsolete. So we are not using capital punishment as of now. So I think you have to memorize, for you to pass the Criminology Board examination, make sure that you memorize aristo minor, the punishment of aristo mayor, prison correctional, prison mayor, reclusion temporal, and reclusion perpetua. Now lastly, under the Criminal Law Book 2, right, in Book 2 of the Criminal Law, you can find the classification of crimes according to the titles. There are actually various titles in the Criminal Law Book 2. The first title is Crime Against National Security and the Law of Nations. So, crimes are also classified in that book. So, the first title is Crimes Against National Security and the Law of Nations. We have treason, espionage, and piracy. For you to be informed about the full list of crimes under this title, you can refer to Criminal Law Book 2. We also have crimes against the fundamental law of the state, like arbitrary detention. We also have crimes against public interest, crimes against public morals, crimes committed by public officers. We also have crimes against persons, crimes against personal liberty and security, crimes against property, crimes against chastity, crimes against the civil status of a person, crimes against honor. So, basically, if we will count the titles like 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, there are 11 titles in Criminal Law Book 2, and these titles arrange various crimes according to its nature. So if the nature is about killing or taking a life from an innocent victim, pwede siyang masulod sa crimes against person. If it is about liberty or freedom, then you will include it as under crimes against personal liberty and security. So basically, again, there are 11 titles under the Criminal Law Book 2 that classified crimes according to its nature. Now, in the Revised Penal Code or in the Criminal Law, there are 4 classification of criminals. So criminals could be classified as recidivist, quasi-recidivist, habitual delinquent, or reiteration or habituality. Let us discuss first what is recidivist. So a person or a criminal can be considered as a recidivist if that at the time of his trial for one crime, he shall be convicted by final judgment of another crime embraced in the same title of the Revised Penal Code. So, for us to understand what is a recidivist, we have to emphasize on different key points. Number 1 is that the person must commit another crime, alright? Meaning he has been convicted for the first crime and he committed another crime. That's the first key point. The second point that I want to emphasize is that for the person to be considered as a recidivist, the second crime should be embraced or should be part of the same title of the Revised Penal Code. These are the qualifications for a person to be considered as a recidivist. Okay? Example, the first crime that he committed is homicide. Alright? Homicide is under the title Crimes Against Person. After he was been in prison for several years, and then let us say he got out from the prison after serving the sentence. After a couple months from the time he get out from the prison, he committed the crime again. He committed the second crime, and the second crime he committed is, let us say, homicide. Even though homicide is a little different from murder, but still homicide, or considering that homicide is with the same title, which is crime against person, that person can be, or that person who committed the act shall be considered as a recidivist. Again, take note that the first crime being committed and the second crime being committed should be within the same title of the Revised Penal Code. So for you to better understand what is a recidivist, I will give you another example. If the person, let us say, committed robbery, okay? Committed robbery in the first crime. He was being judged, he was being put into prison, and he was being released after serving the sentence. After a couple of months or after a considerable time, he committed another crime or second crime. Let us say, this time he committed burglary. Burglary, when you destroy a particular property for you to have entrance into. So in this case, robbery is a crime against property. burglary, on the other hand, is still under the title crimes against property. So in this case, the second crime he committed is burglary. The person can now be considered as a recidivist. If you committed murder on the first crime, then when you get out from the prison, you get committed again the same crime like murder again, still you will be considered as a recidivist. You committed robbery in the first crime, and in the second crime, same lang Japon, robbery, matawag Japon siya og recidivist. Again, we have to consider two things. One, you have been convicted of the first crime. Second, the second crime you committed should be of the same title of the revised penal code. That's recidivism or recidivist. A criminal can also be considered as a quasi-recidivist if he commits another crime after having been convicted by final judgment of a crime before beginning or while serving the sentence. I repeat, before you are serving or while you are serving the sentence, you committed another crime. Okay? Again, 2 points that you have to consider. 1, you have been convicted by final judgment of the first crime. 2, while you are serving or before you serve the sentence, you committed another crime. Then the person in that case shall be considered as a quasi-recidivist. Another example, like you committed murder. You have been judged and you have been found guilty beyond reasonable doubt, and you have been put into the prison institution. While you are serving your sentence inside the prison institution, you committed, let us say, physical injury, or you committed homicide, or maybe you committed another form of crime. As long as you are inside the prison, in that case, you shall be considered as a quasi-recidivist, considering that while at the verge or at the point that you are serving, you committed another crime. Remember, cadets, that the person cannot be considered as a quasi-recidivist if he is only detained. Okay? If he is only detained, like a person is a detainee only, and he committed a crime while he was being detained, that shall not qualify for quasi-recidivism. Again, the qualification is that you must be convicted of the first crime. And while you serve or before you serve the sentence, you committed another crime. Okay, that's quasi-recidivism. But if you are not convicted because you are just detained and you committed a crime, that will not qualify for quasi-recidivism. Next, habitual delinquent. One who within the period of 10 years from the date of his release or last conviction of the crimes of, number 1, serious physical injury. Number 2, less serious physical injury. Number 3, robbery. Number 4, estafa. Number 5, falsification, is found guilty of any of the said crimes for the third time. For the third time or oftener. Ang giyon diri ha, una, 10 years from the date of his release, you committed another serious crime. 5 lang nakabukang gimension: serious physical injury, less serious physical injury, robbery, estafa, falsification, for the third time. Okay? So if it is just your second time, you shall not be considered as a habitual delinquent. Or if it does not lapse within 10 years as required by the law, you shall not be qualified for habitual delinquent. It should be within the period of 10 years from the date of your release. Okay? Within the period of 10 years from the date of your release. At the same time, it should be third time. And on the other instance, you have to consider that the serious crimes should only cover the 5 crimes being mentioned in here. Okay? So, if you committed another type of crime and it is not third time or it is not within 10 years, then you shall not be considered as a habitual delinquent. The next one is reiteration or habituality, where the offender has been previously punished for an offense to which the law attaches an equal or greater penalty, or for 2 crimes to which it attaches a lighter penalty. Previous offenses must not be the same title in the revised penal code. So in the case of you have committed murder and you get out from the prison after you serve the sentence, and you committed, let us say, robbery. Robbery is crimes against property. The first crime that you have is murder, and murder is against crimes against person. So in this case, they do not contain in the same title. Murder under crimes against person, robbery is under the title crimes against property. So the person shall not be considered as a recidivist, but rather he shall be considered under reiteration or habituality. So those are the differences between the four classification of criminals. Part of the discussion under Introduction to Criminology is about crime volume, crime clearance efficiency, and crime solution efficiency. So this will be the last topics that we are going to discuss under the subject Introduction to Criminology. So what is crime volume? This is also one of the topics under law enforcement organization, but I will just give you the bird's eye view. Crime volume refers to the crime incidents committed in a given area over a period of time, which include the index and non-index crimes. So crimes are classified in the police reporting as index crimes or non-index crimes. So index crimes plus non-index crimes, that will resort to what we call as crime volume. So if, let us say, there are 10 index crimes on a particular month and 5 non-index crimes, so 10 plus 5, your crime volume is 15. On the other hand, for us to understand what is index crimes and non-index, we will take a look on the definition. In the index crimes, you consider a particular crime as indexed once this is serious in nature. Okay? Serious in nature and which occur with sufficient frequency and regularity such that they can serve as an index to the crime causation. So if it occurs regularly with several times and it is serious in nature, it shall be considered as an index crime. And remember, cadets, only the crimes of number 1, murder, number 2, homicide, number 3, serious physical injury, number 4, less serious physical injury, number 5, carnapping, number 6, cattle rustling, number 7, robbery, number 8, theft, and number 9 is rape. These are crimes that are considered as index crimes. If the particular criminal act is not part under the crimes that I enumerated ago, that crime shall not be considered as index, but rather non-index crime. Why non-index crime? Because it is not included in the list. Okay? For example, if I would say treason. Treason is a non-index crime. Why? Because it is not part of the list. Concubinage. Concubinage is not again part of the index crime. Adultery. Adultery is not part of the list. So therefore, you consider it as a non-index crime. How many again? How many crimes are under the index crimes? There are only 9. Okay? Next, aside from the index crimes, part of the police reporting would be the crime rate. By the way, where will you get the data in the index and the non-index crime? The data can be located in the police blotter. So if you will go to the police station, the desk officer has with him on the table a blue book, a blue logbook that contains the blotter entry. So the person who is in charge to do the reporting about the crime volume or the crime rate will be the crime registrar. The reporting can be done every year, annually, or per month. Alright? Per month or annually. So that is the responsibility of the crime registrar. Again, where does the crime registrar get the data? The data will be taken from the police blotter. So what is a crime rate? A crime rate refers to the number of crime incidents in a given period of time for every 100,000 inhabitants of an area. The number which is 100,000 is constant in the calculation of the crime rate. I provided you in the example. As you can see on your screen, there is an example, guys. So the calculation would be number of crimes over population times 100,000. That will be your crime rate per 100,000. So an example is, in 2010, there were 58,100 robberies in Samar, and the population was 38,826,898. So if you will follow the formula, the number of crimes over the population, so 58,100 over 38,826,898, this equals to a robbery crime rate of 149.6. 149.6 per 100,000 general population. So that's how you will interpret, that's how you will get, or how you will interpret the crime rate. So again, number of crimes divided by population times 100,000, that will be your crime rate. Okay? So aside from the crime rate, the next one is crime solution efficiency. We also have a formula. Crime solution efficiency is equal to solved cases divided by the crime volume multiplied by 100. Again, what is crime volume? Crime volume refers to the sum between the index crime and the non-index crime. Okay? So crime solution efficiency is the percentage of solved cases out of the total number of crime incidents handled by law enforcement agencies for a given period of time. So let us say, for example, in 1 month, there are 300 criminal cases. But the police officers only was able to solve, let us say, 100 cases. Okay, 100 cases. So in that example, 100 cases would refer to the solved cases. Okay? Well, the 300 would refer to your crime volume. So you will say 100 divided by the crime volume, which is 300, divided or multiplied by 100. The result will be your crime solution efficiency. We also have crime clearance efficiency. It is the percentage of cleared cases out of the total number of crime incidents handled by law enforcement agencies for a given period of time. Same formula, the only difference is that in here, what is given importance are cleared cases. In the previous, what is given importance are solved cases. So in this case again, cleared cases divided by the crime volume, you multiply it by 100, that is your CCE. Now, for us to understand, when can we say that a crime is case closed or case cleared, let us find out the explanation on your screen. Alright? So I hope this will be understood, the difference between case closed and case cleared. So a case is considered as solved when the offender has been identified and there is sufficient evidence to charge him, the offender has been taken into custody, and the offender has been charged before the prosecutor's office, or when some elements beyond police officers' control prevent the arrest of the offender. When a case is no longer being investigated and is not assigned to an investigator, the case is closed. A closed case can either be solved or unsolved. Why when you say unsolved? Simply because if there is no lead, there is no evidence that could trace to the identity of the perpetrator, then that's the time that you have to put it aside, put the investigation aside, and you consider it as unsolved case. But again, that will form part under case solved. Okay? So, a case, all of the cases being considered as solved will form part under crime solution efficiency or solved cases. A case is cleared, on the other hand, when at least one of the offenders has been identified, there is sufficient evidence to charge the suspect and he has been charged before the prosecutor's office. So if you will take a look at the difference on your screen, reflected on your screen right now, you will say that the only difference between case solved and case cleared is that in case solved, the offender is already arrested. The person charged with a crime is already in custody. When you say in custody, he is already put behind bars. Okay? But in case cleared, even though you identify the person, you have sufficient evidence about the person, you have filed a complaint before the prosecutor's office, but the person to be arrested is still at large, meaning the person is still at the community. The person is still roaming at the community, or the person is not yet arrested, the case shall be considered as cleared. Okay? Again, you identify the person, you have the evidence, you filed the complaint, but you failed, or you were not able to arrest the person, or the person is still at large, you consider it as case cleared. But if the person has already been arrested, there are sufficient evidences, a complaint has already been filed, then you consider it as case closed. So that's how you will distinguish whether a crime is case closed or case cleared. So again, I've already provided you with a formula on crime clearance efficiency and crime solution efficiency. So lastly, we have National Crime Reporting System, which consists of details of the crime, which includes the victim and the offender's data. National Crime Reporting System will actually reflect the criminal data, and this data were actually taken from the police blotter per station. Okay? So if you have the municipal station in your respective municipality, they will transmit the data to the national office for the National Crime Reporting System. So lastly, we have Police Regional Office Periodic Report concerned with the 5 Ws and 1 H, so as the result of the investigation. So 5 Ws and 1 H refers to the cardinal rules of investigation: the why, the who, the where, the what, the when, and the how. Okay, these are considered as the cardinal rules of investigation, which will also be reported not just to the regional office but also to the national headquarters. So those are the topics that are covered under Introduction to Criminology. Again, the discussion in this subject comprises 4 episodes because this is quite broad. Again, Intro to Crim is very important because this is a springboard to all major subjects. So we have 4 episodes again: episode 1, episode 2, episode 3, and this last episode. So if in case you have questions that you want to be clarified with in any area of the episodes or in any area of the topics being discussed, there is a comment section below. You can tap, or you can post your questions in the comment section, and if in case I have a vacant time or by due time, I may take a look at it and provide you with an equivocal answer. So thank you so much for watching, and thank you so much for listening. I hope you learned something. God bless you and stay safe.